Your logging operation is in violation of community forestry covenants. You have 14 days to cease all timber activity, or Pinewood Heights HOA will pursue injunctive relief. 1 page, certified mail, signed by someone named Patricia Voss, President. For trees I had been cutting on land I owned outright. 1,800 acres of mixed hardwood and pine that had been in my family since 1891. They showed up in a white Lexus SUV, handed me that envelope like they were serving a warrant, and they had no idea. No idea that the gated entrance they drove through every morning, the community center where they held their monthly meetings, the paved walking trail they called an amenity, all of it sat on an access easement I had granted 22 years ago, revocable with 90 days' notice. I hadn't revoked it. I hadn't threatened it. I had simply never mentioned it. Drop a comment, tell me where you're from, and if something like this has ever happened to you, I want to hear it. The morning they showed up, I was running the skidder along the North Ridge, pulling white oak logs down to the staging area near the old mill road. The air smelled of fresh-cut wood and diesel exhaust, and the ground was soft enough that the skidder's tires left deep tracks in the clay. This was Mercer Forest. 1,800 acres my great-grandfather Samuel bought in 1891 for $2,200 paid in cash he had saved working timber camps in Michigan. 4 generations. My father taught me to read a stand the way Samuel had taught him, which trees to take, which to leave, how to thin a ridge so the remaining timber grew straight and strong. Every log I pulled was part of a rotation Samuel started, something I intended to continue. The ridge stretched out to my left, a long spine of oak and hickory running north toward the county line. A pair of crows worked the canopy, calling to each other in short, flat notes. This was my land, and I worked it the way it had been worked for over a century. I heard the vehicle before I saw it. Too clean, too quiet, the kind of SUV that had never left pavement. It stopped at the edge of the clearing, and 2 people stepped out wearing business casual like they were attending a conference, not walking a logging site. One of them was a woman in her mid-50s, blonde hair pulled back, holding a yellow envelope with both hands like it was a subpoena. The other was younger, a man in khakis and a polo shirt with an embroidered logo I couldn't make out from that distance. They picked their way across the rutted ground, stepping carefully around the mud, and I shut down the skidder and climbed out to meet them. The woman introduced herself as Patricia Voss, president of Pinewood Heights HOA. She said it the way someone says a title they believe carries weight. Her colleague stood a half step behind her, holding a tablet, not quite meeting my eyes. She told me I was in violation. Unauthorized logging activity, failure to comply with community forestry management standards, operation of heavy equipment in a designated conservation zone. The words came out smooth and practiced, but there was something underneath them. A slight tightness in her voice when I didn't react, a quick glance at her colleague when I just stood there listening. They were expecting something other than stillness. I took the envelope, thanked them for coming out, and waited until they had driven away before I opened it. The letter was 1 page, dense with language designed to sound more legal than it was. A demand to cease all timber operations within 14 days. A list of violations that read like someone had walked my property with a checklist built for a suburban planned community, not the working forest that had existed for over a century. And at the very bottom, a line I read twice. Failure to comply will result in HOA pursuing all available legal remedies, including injunctive relief and daily fines. I didn't know what legal basis they thought they had. I suspected they didn't either. But I noticed something more important than the demand, more important than the language. The letter contained no citation, no recorded covenant, no legal instrument that established how, exactly, Pinewood Heights HOA had jurisdiction over land that had never been part of their development. I folded the letter along its original crease and put it in the glove box of the skidder. Then I looked south across the property, past the old logging road, toward the cluster of buildings at the far edge of my land, the HOA's development. A gated entrance with brick columns and wrought iron, a community center with a stone facade, a network of paved walking trails that wound through what they called conservation areas. Neat, established, permanent-looking. I had driven past it 100 times without giving it much thought, because there was nothing to think about. The access easement I had granted in 2001 was clear. Pinewood Heights Development, LLC could use the old mill road and 40 acres of buffer land for ingress, egress, and recreational trails, as long as the development maintained the road and respected the boundaries. But standing there with their letter in my glove box, I found myself looking at those buildings differently. Not with anger, with something slower. Recognition, maybe. My name is Daniel Mercer. I am 61 years old. I have worked this forest since I was 16, first alongside my father, then alone after he passed in 1998. I am a timber consultant, a licensed forester, and the sole owner of 1,800 acres of mixed hardwood and pine in the northern corner of Cascade County. The deed is in a fireproof safe in my office, along with the survey maps, the timber management plan, and the easement agreement that Pinewood Heights seems to have forgotten they signed. My great-grandfather Samuel Mercer bought this land in 1891 with money he earned the hard way. 14 years working timber camps in Michigan, sleeping in bunkhouses, sending half his pay home to his mother. When he finally had enough saved, he came south and bought 1,800 acres of cut-over forest that no one else wanted, land that had been logged once already and left to grow back wild. He built a cabin on the ridge, married a schoolteacher named Eula, and spent the next 40 years turning that cut-over land into a working forest. He planted white pine in the clearings, thinned the oak stands, cut selectively, and replanted what he took. By the time my grandfather Thomas inherited it in 1931, the forest was producing again. Not fast, but steady, the way a forest should. Thomas passed it to my father in 1967, and my father passed it to me in 1998. Each generation added something. A better road, a staging area, a management plan that tracked every stand and every rotation. My father taught me to walk the ridges in early spring, before the canopy filled in, so I could see which trees were crowding each other, which needed to come out so the rest could grow. He taught me that a forest is not a garden. You do not control it. You guide it. You take what is ready, you leave what is not, and you never take more than the land can replace. It was not romantic. It was work. But it was work that connected me to something older than myself, and I had learned to value that. The deed is simple. 1,800 acres, meets and bounds, recorded in 1891 and updated in 1952 when the county switched to a new survey system. No restrictions, no covenants, no conservation easements, just land and the right to use it as I saw fit, within the law. I had never sold an acre. I had never given an acre away. What I had done in 2001 was grant an access easement to Pinewood Heights Development, LLC, 40 acres of buffer land along the southern boundary, plus the right to use the Old Mill Road for ingress and egress. The easement was recorded, notarized, and filed with the county. It was also revocable with 90 days written notice, a clause the developer had agreed to because he needed access, and I was the only landowner who could provide it. The development went up fast. 200 homes, all of them priced in the upper range, all of them marketed as mountain living with modern amenities. The HOA, formed in 2002, took over management from the developer and settled into a routine I rarely thought about. They maintained the Mill Road, which saved me the cost of grading it myself. They built their trails and their community center and their gated entrance, all of it on the 40-acre easement I'd granted. And every month, like clockwork, I received a small payment from the HOA, $300 compensation for the easement, a gesture the developer had offered and I had accepted because it seemed fair. I didn't need the money, but I appreciated the principle. For 22 years, we had no contact. I logged my land. They lived in their houses. The arrangement worked because neither side had a reason to change it. And then Patricia Voss handed me that letter, and I realized the arrangement was about to become something else. I called my attorney the next morning. His name is Lawrence Gibbs, and he has handled every piece of legal work my family has needed since 1985. Timber, contracts, estate planning, the occasional boundary dispute. He is 68 years old, semi-retired, and he works out of a small office above a hardware store in town. I trust him because he does not bill in 6-minute increments, and he does not use words he does not need. I read him the letter over the phone. He listened without interrupting, and when I finished, he was quiet for a long moment. Then he said, "Do you have the easement agreement?" I told him I did. He said, "Bring it in. Bring the deed. Bring anything they've sent you in the last 5 years." I met him that afternoon. His office smelled of old paper and coffee that had been sitting too long on the burner. He read the letter twice, then pulled the easement agreement from the folder I had brought and read that even more slowly. He made notes on a yellow legal pad in handwriting I could not decipher. Then he looked up and said, "They don't have standing." I waited. He said, "The easement grants them access and recreational use of 40 acres. It does not grant them authority over your timber operations. It does not grant them regulatory control. It doesn't grant them anything except the right to drive on your road and walk on your trails. This letter is nonsense." I asked him what I should do. He said, "Respond in writing. Cite the easement. Cite the deed. Tell them politely that they have no legal basis for the demand, and that you intend to continue operating your land as you see fit. Then we wait and see if they're smart enough to back down." I drafted the response that night. It was 1 page, calm and factual. I cited the deed, the easement agreement, and the absence of any recorded covenant that would give Pinewood Heights HOA authority over timber operations on land they did not own. I stated that I had operated this forest in compliance with state and county forestry regulations for over 40 years, and that I intended to continue doing so. I closed by noting that the $300 monthly easement payment, while appreciated, did not constitute a transfer of ownership or regulatory authority. I sent it certified mail the next morning. Patricia Voss's response arrived 11 days later. 2 pages this time, on HOA letterhead, signed by both Voss and someone identified as the HOA's legal counsel. The tone had shifted, less demand, more threat. The letter claimed that the easement agreement included an implied covenant to maintain the environmental and aesthetic character of the buffer zone, and that my logging operations were degrading that character in violation of the agreement. It cited no case law, no statute, no specific language from the easement that supported the claim. But it did include a new demand: immediate cessation of all logging activity within 500 feet of the easement boundary, pending a third-party environmental assessment to be paid for by me. I read it twice, then called Lawrence. He told me to bring it in. This time, when I arrived at his office, he had the county plat maps spread across his desk. He had highlighted the easement boundary in yellow and my property line in red. He pointed to the area Patricia Voss was now claiming I could not log, a strip of land roughly 500 feet wide, running the entire length of the easement boundary. He said, "That's 60 acres. She's trying to create a de facto conservation zone on your land without paying for it." I asked him if the easement language supported her claim. He said, "No, the easement is explicit, access and recreational use. Nothing about environmental character, nothing about logging restrictions. She's making it up." I asked him what came next. He said, "She'll either back down or she'll file for an injunction. If she files, we go to court and we win. But it'll cost you time and money, and she knows that. She's betting you'll fold before it gets that far." I told him I would not fold. He nodded, like he had expected that answer. Then he said, "There's one more thing you should know. I pulled the HOA's corporate filings this morning. Patricia Voss has been president for 8 years. The board hasn't changed in 6. They've never been challenged on anything, and they've never lost a dispute. They're used to people backing down." I said, "Then this will be a new experience for them." He smiled, just slightly, and said, "I'll draft a response. We'll make it clear that you're not interested in negotiating away rights you didn't grant in the first place." Lawrence's response went out 3 days later, and it was colder than anything I would have written myself. He cited the easement agreement paragraph by paragraph, quoted the recorded deed, and included a copy of the original 2001 survey that showed exactly where my property ended and the easement began. He pointed out that the phrase environmental and aesthetic character appeared nowhere in the easement language, that no implied covenant could override explicit contractual terms, and that any attempt to restrict my timber operations on land I owned outright would constitute tortious interference with my business. He closed with a sentence I read twice because of how carefully it was worded. "Mr. Mercer has operated this forest in full compliance with state and federal forestry regulations for over 4 decades, and he will continue to do so regardless of any unfounded claims made by parties with no legal standing to restrict his use of his own property." I expected silence after that. What I got was escalation. The next letter arrived from a law firm in the state capital 90 miles south. Kellerman and Associates, 3 attorneys listed on the letterhead, the kind of firm that handles municipal contracts and zoning disputes. The letter was addressed to me but copied to Lawrence, and it opened with a paragraph that tried to sound conciliatory while delivering the same demand. The HOA, it said, remained concerned about the environmental impact of logging operations in proximity to the residential community, and while they recognized my property rights, they believed a compromise could be reached that would protect both parties' interests. The compromise, as they described it, was this: I would agree to a 500-foot no-log-in buffer along the entire easement boundary, submit to an environmental assessment conducted by a consultant of the HOA's choosing, and allow the HOA to review and approve any future timber management plans that affected land within 1,000 feet of the easement. In exchange, the HOA would withdraw its demand for immediate cessation and agree not to pursue further legal action. I read it standing in my kitchen, the morning light coming through the window above the sink. Outside, a light rain was falling, the kind that barely made a sound against the roof but left the driveway slick and dark. I could see the ridge through the window, the line of oaks running north, their branches bare and black against the gray sky. I had walked that ridge 2 days before, marking trees for the next rotation, and I had not thought once about the HOA or their letters or their lawyers. I had thought about the spacing between the oaks, about which trees were crowding the younger growth, about whether the stand would be ready in 5 years or 10. That was the work. That was what mattered. And now someone 90 miles away, someone who had never set foot on my land, was telling me I needed their approval to continue it. I called Lawrence and read him the letter. He was quiet for a moment, then he said, "They hired Kellerman to intimidate you. It won't work, but that's the strategy." I asked him what he meant. He said, "Kellerman charges $400 an hour. The HOA is spending money to make you think they're serious, to make you think this is going to cost you more than it's worth. They want you to accept the compromise because it's easier than fighting." I said, "I'm not accepting it." He said, "Good, because the compromise isn't a compromise, it's a land grab. They're asking you to give up 60 acres of timber rights, submit to their oversight, and pay for the privilege. If you agree to that, you set a precedent, and 5 years from now they'll be back asking for more." I asked him what we should do. He said, "We file a declaratory judgment action. We go to court and ask a judge to declare on the record that the easement agreement means exactly what it says and nothing more. We force them to prove their claim in front of a judge, and when they can't, we get a ruling that ends this." I asked him how long that would take. He said, 4 months, maybe 6, but it'll be over, and you'll have a court order that says they have no authority over your timber operations. That's worth the time. I told him to file it. The complaint was 12 pages, and Lawrence walked me through it in his office before we filed. It named Pinewood Heights HOA as the defendant and asked the court for a declaratory judgment, establishing that the 2001 easement agreement granted the HOA access and recreational use only, with no authority to regulate or restrict timber operations on the remaining 1,760 acres of my property. It cited the deed, the easement, and the absence of any recorded covenant that would support the HOA's claims. It also asked the court to award me attorney's fees and costs, which Lawrence said was standard in cases where the plaintiff was forced to defend clear property rights against baseless claims. We filed it on a Thursday morning in late November. The courthouse smelled of floor wax and old wood, and the clerk who accepted the filing barely looked at it before stamping it and handing me a copy. Lawrence said the HOA would have 30 days to respond, and that we should expect their response to be aggressive. He was right. The HOA's answer arrived 28 days later, and it was twice as long as our complaint. Kellerman and Associates had drafted it, and the strategy was obvious. Bury the court in arguments, raise every possible defense, and hope something stuck. They denied that the easement was limited to access and recreational use. They claimed that the phrase recreational use necessarily implied a right to preserve the environmental character of the recreation area. They argued that my logging operations created noise, dust, and visual blight that interfered with the HOA's members' quiet enjoyment of the trails. They even suggested that the original developer had intended to include logging restrictions in the easement, but that the language had been inadvertently omitted, and that the court should reform the contract to reflect that intent. Lawrence read it, shook his head, and said, "They're throwing everything at the wall. None of it will stick, but it'll drag this out." I asked him how long. He said, "They'll want discovery, depositions, document requests, interrogatories. They'll try to make this expensive and complicated because that's the only leverage they have." I said, "Let them try." Discovery began in January. Kellerman sent a document request that ran 14 pages and asked for every piece of paper related to my timber operations going back 20 years. Contracts, invoices, management plans, correspondence with state forestry officials, financial records, tax returns. Lawrence objected to half of it as overly broad and irrelevant, but the judge allowed most of it, and I spent 3 weeks pulling files from my office and the storage shed behind my house. I made copies of everything, boxed it up, and sent it to Kellerman's office with a cover letter that said nothing except enclosed, "Please find documents responsive to your request," dated January 8th. They sent me interrogatories next, 40 questions, each one designed to take an hour to answer. They asked me to describe every logging operation I had conducted since 2001. They asked me to identify every piece of equipment I owned and every contractor I had hired. They asked me to estimate the total board feet of timber I had removed from land within 1,000 feet of the easement boundary, broken down by species and year. Lawrence helped me draft the answers, and we kept them factual and precise. Yes, I had conducted logging operations. Yes, I owned a skidder, a chainsaw, and a pickup truck. Yes, I had removed approximately 1.2 million board feet of timber from the North Ridge between 2001 and 2023, all of it in compliance with my state-approved timber management plan. Then came the depositions. Kellerman scheduled mine for a Friday morning in March at their office in the Capitol. I drove down the night before and stayed in a motel near the courthouse, a 2-story building with an ice machine that rattled all night. Lawrence met me in the lobby at 8 a.m., and we walked 2 blocks to Kellerman's office, a renovated brick building with tall windows and a reception area that smelled faintly of coffee and leather. The lead attorney was a man named Richard Kellerman, mid-40s, gray suit, the kind of handshake that lasted a half-second too long. He introduced himself, introduced the court reporter, and gestured to a chair at the end of a long conference table. The deposition lasted 4 hours. Kellerman asked me about the history of the land, about my timber operations, about my understanding of the easement agreement. He asked me whether I had ever discussed logging restrictions with the original developer. He asked me whether I believed my logging operations created noise or visual impact. He asked me whether I had considered the effect of those operations on the property values of the homes in Pinewood Heights. I answered every question the same way Lawrence had told me to, briefly, factually, without elaborating. No, I had never discussed logging restrictions with the developer. Yes, logging creates noise. That is the nature of the work. No, I had not considered the effect on property values, because property values were not my concern. Kellerman tried to rattle me. He asked whether I thought it was fair to operate heavy equipment near a residential community. He asked whether I had any regard for my neighbor's quality of life. He asked whether I understood that the HOA's members had invested significant money in their homes and expected a certain standard of environmental stewardship. I looked at him and said, "I understand that they bought homes next to a working forest and that the forest was here first." He didn't like that answer, but he moved on. The deposition ended just after noon. Lawrence and I walked back to the motel parking lot and he said, "You did well. He didn't get anything he can use." I asked him when we would get a trial date. He said, "Soon. The judge will want to move this along once discovery closes." Discovery closed in April. By then, I had produced over 2,000 pages of documents, answered 40 interrogatories, and sat for a 4-hour deposition. The HOA had produced almost nothing. A copy of the easement agreement I already had, a few meeting minutes where they had discussed my logging operations, and a 2-page letter from a consulting forester they had hired who claimed without visiting my property that my operations were inconsistent with sustainable forestry practices. Lawrence filed a motion for summary judgment in May, arguing that the undisputed facts established that the easement granted no authority over my timber operations and that the HOA's claims failed as a matter of law. The hearing was set for June 14th in the county courthouse in front of a judge named Harold Penfield. I had never met him, but Lawrence said he was fair, methodical, and intolerant of wasted time. The courtroom was smaller than I expected, wood-paneled and warm, with high windows that let in slanted morning light. I sat at the plaintiff's table next to Lawrence, and across the aisle sat Richard Kellerman and Patricia Voss. She was wearing a navy suit and pearl earrings, and she did not look at me once. Judge Penfield entered, and we stood. He was in his late 60s, white hair, reading glasses on a chain around his neck. He sat, opened the file, and said, "Counsel, I've read the briefs. Mr. Gibbs, this is your motion. You may proceed." Lawrence stood and walked to the podium. He spoke for 12 minutes, and he did not raise his voice once. He walked the judge through the easement agreement, line by line. He pointed out that the agreement granted access and recreational use, nothing more. He noted that the HOA had produced no evidence, no contract language, no correspondence, no meeting minutes from 2001 that suggested the parties had ever discussed or intended logging restrictions. He cited 3 cases where courts had refused to imply restrictions into easement agreements that did not contain them. He closed by saying, "Your Honor, the HOA is asking this court to rewrite a contract that is clear on its face. The law does not permit that, and the facts do not support it." Judge Penfield nodded and turned to Kellerman. "Mr. Kellerman, your response." Kellerman stood, and he tried. He argued that the phrase recreational use had to be interpreted in light of the surrounding context, that no reasonable person would grant recreational trail access while simultaneously conducting industrial logging operations that degraded the trails. He argued that the court should consider the intent of the parties, not just the words on the page. He argued that my logging operations interfered with the HOA's use and enjoyment of the easement, and that equity required some restriction to balance the competing interests. Judge Penfield let him finish, then he took off his glasses and said, "Mr. Kellerman, where in the easement agreement does it say anything about logging?" Kellerman hesitated. "It doesn't explicitly address logging, Your Honor, but where does it say anything about environmental character?" "It doesn't use that phrase, but the implication, where does it say that Mr. Mercer must submit his timber operations to HOA review?" Kellerman said, "Your Honor, We're asking the court to interpret the agreement in a way that gives effect to both parties' reasonable expectations." Judge Penfield put his glasses back on. He said, "Mr. Kellerman, I don't interpret contracts by guessing what the parties might have expected. I interpret them by reading what they wrote. And what they wrote is an easement for access and recreational use. That's all." He looked down at the file for a long moment. Then he said, "The motion for summary judgment is granted. The easement agreement grants Pinewood Heights HOA the right to use the designated access road and trails for ingress, egress, and recreational purposes. It does not grant the HOA any authority to regulate or restrict timber operations on land owned by Mr. Mercer. The declaratory judgment will so state. Mr. Gibbs, submit a proposed order within 10 days. He stood, and we stood, and he left the courtroom. Patricia Voss walked out without a word. Kellerman gathered his files, shook Lawrence's hand with a tight smile, and followed her. Lawrence and I stood there for a moment in the empty courtroom, and then he said, "That's it. It's over." I nodded. It felt quieter than I had expected. The declaratory judgment was entered on June 22nd. Lawrence sent me a copy by email that afternoon, and I printed it at home and read it standing at my kitchen counter. 3 pages, typed on court letterhead, signed by Judge Penfield. The language was spare and absolute. The court found that the 2001 easement agreement between Daniel Mercer and Pinewood Heights Development, LLC, granted the HOA access and recreational use of the designated roadway and trail areas only. The court found that the agreement contained no language restricting timber operations, no language requiring environmental review, and no language granting the HOA regulatory authority over land retained by the grantor. The court declared that Pinewood Heights HOA had no legal standing to regulate, restrict, or interfere with timber operations conducted by Daniel Mercer on property he owned in fee simple. The court awarded me attorney's fees and costs in the amount of $18,400. The judgment was final and binding. I set the paper down and looked out the window. The ridge was green now, the canopy filled in, and a light wind moved through the oaks in a way that made the whole hillside seem to breathe. I had not stopped working while the case moved through the courts. I had marked trees, pulled logs, replanted clearings. The forest had continued, indifferent to the dispute, and I had continued with it. The judgment did not change that. It simply confirmed what I had always known. Patricia Voss did not appeal. Kellerman and Associates sent a brief letter acknowledging the judgment and stating that the HOA would comply with its terms. There was no apology, no acknowledgement of overreach, just a single sentence that said the matter was closed. I filed the letter with the rest of the correspondence and did not think about it again. The HOA paid the attorney's fees in 2 installments, one in July and one in August. Lawrence deposited the checks and sent me a final accounting. His bill had come to $22,100, which meant the judgment covered most of it and I paid the remaining $3,700 out of pocket. I wrote the check without hesitation. The cost was real, but it was also finite, and it had bought me something more valuable than money: certainty. The easement meant what it said. The land was mine. No one could take that away by writing a letter on HOA letterhead. I saw Patricia Voss one more time in late September at the hardware store in town. She was standing in the paint aisle, holding 2 sample cards up to the light, and she did not see me. I walked past without stopping. There was nothing to say. The court had said it all. The HOA continued to use the mill road and the trails just as the easement allowed. I continued to receive the $300 monthly payment, and I continued to log the North Ridge according to the rotation schedule my father had started and I had refined. The arrangement was exactly what it had been before Patricia Voss handed me that first letter, except now it rested on a foundation the court had made explicit. The easement was not a favor. It was a contract, and contracts have limits. I thought about that sometimes, walking the property in the early morning before the heat set in. The forest did not care about contracts or judgments or letters from lawyers. It grew according to older rules: light, water, soil, time. But the forest existed inside a world of human claims, and those claims had to be settled according to human rules. The deed was one of those rules. The easement was another, and the judgment was the third, the one that made the others enforceable. My great-grandfather Samuel had understood that. He had bought this land with cash in 1891, and he had recorded the deed the same day. He had known that ownership was not just possession, it was documentation, a piece of paper that said the land was his and no one else's. He had taught that to my grandfather, and my grandfather had taught it to my father, and my father had taught it to me. The lesson was simple. The land is only yours if you can prove it. I had proven it. The forest stretched out in front of me, the ridge running north toward the county line, the oaks standing tall and straight in the morning light. I could see the trail from where I stood, a narrow dirt path winding through the trees, and I could see two people walking it, a man and a woman in athletic clothes, moving slowly, talking quietly. They were HOA members, I assumed, using the easement the way the easement allowed. They did not see me. They did not know I was there. And that was fine. The forest was big enough for all of us, as long as everyone stayed on their side of the line. I walked back to the house, past the staging area where the logs were stacked and waiting, past the skidder parked under the lean-to, past the shed where I kept the chainsaw, and the fuel cans and the tools I had inherited from my father. The air smelled of pine and cut grass, and the ground was soft under my boots. This was my land. It had been my land before Patricia Voss was born, and it would be my land long after she was gone. The deed said so. The court said so, and that was all that mattered. I thought about the letter sometimes, the one that had started all of this. The demand to cease logging operations, the threat of injunctive relief, the language designed to sound more legal than it was. I thought about how easy it would have been to comply, to stop working, to avoid the conflict. And I thought about what I would have lost if I had done that. Not just the timber, not just the income, but something deeper. The right to use my own land as I saw fit within the law, without asking permission from people who had no authority to grant it. That right was not abstract. It was recorded, notarized, filed with the county. It was the deed my great-grandfather had paid for in 1891, the easement I had granted in 2001, and the judgment Judge Penfield had entered in 2023. It was a line on a map, a signature on a contract, a ruling in a court file. And it was real. When an institution with apparent authority makes a claim against you, the first question is not whether the claim is reasonable, or fair, or well-intentioned. The first question is whether the claim has a legal foundation, and the answer to that question is always in the record. Not in what someone says, not in what someone believes, not in what seems right or seems wrong. In the record. The deed, the easement, the survey, the statute, the case law, the contract, the things that can be read, cited, proven. Patricia Voss had made a claim without a foundation, and the record had proven her wrong. That was all this had ever been. A question and an answer. I stood at the edge of the ridge that evening, watching the light fade over the valley. The oaks were dark against the sky, and the air had cooled enough that I could feel it on my skin. Somewhere below, the trail wound through the trees, and somewhere beyond that, the homes of Pinewood Heights sat quiet and lit. I did not think about them often. I did not need to. The forest was here. The deed was here. And I was here, standing on land my family had earned and kept and passed down, one generation to the next. The work would continue. The forest would continue. And the line between what was mine and what was theirs would remain exactly where it had always been, clear and bright and recorded. If you have a story like this, a boundary dispute, an HOA claim, a piece of land someone tried to take, drop it in the comments. I want to hear it. And if you want to see how the next case plays out, subscribe. There is always another case.